This is a mistake that anybody could make because it is really confusing. And what that is confusing probate assets with non-probate assets, confusing the will with what it governs with what it does not govern. So that confusion, very understandable. You might be the executor and you're saying, well, under the terms of the will, it says, everybody shares equally. And I mentioned before that if your job as the executor is to be aware of non-probate assets, the life insurance policy, the 401k, the IRA, and you as an executor don't control that asset, the beneficiary designation on that non-probate asset does. So your job as an executor is to know about it, put it on the inventory, but your job isn't to say, hey, you received mom's IRA, it was directed 100% to you, but it really is supposed to be divided 5 ways, because that's not how it was set up. And if mom intended that IRA to go 5 ways, then that's going to create a lot of complications. Person receiving the IRA, I don't even want to get into the complications. But what I want you to understand as the executor is that beneficiary designation on that IRA controls, not the will that you are administering. So one of the ways to make this easier is that before the death of the person whose estate you're administering, that you sit down with them and maybe their attorney, and you say, I just want to understand what the estate looks like, what are the assets, what my job is going to be. That way it's going to be much easier for you when you have to assume that role. And also that way you might get a better education about what probate versus non-probate assets are. And by asking these questions, you might find out, or the decedent before their death, mom, for example, might find out, oh, I didn't know that I shouldn't set up that non-probate asset to pay to just one person. I really wanted it to pay to, all 5 of you. So that's, I guess, planning in advance of death is one of the best things that can be done to make your job easier as an executor. So if you do have that opportunity, it's not like you're saying, mom, where's the money now? You're saying, I'm your executor, mom. I want to make sure that I do exactly what you want me to do. And I want to understand my job so we can sit down and go over it together. Can we talk to the attorney and make sure that we're all on the same page? That's probably the best advice I give you, is do these sorts of things in advance of somebody's death. Let me give you one other example of the confusion between probate and non-probate assets, and we see this very, very commonly. Let's say that investment account mom has is worth, $200,000, $500,000, whatever it is. And what they did on that investment account, what mom did, was for ease of estate administration, rather than just having it directionless so it would pay to the estate to be distributed as a probate asset under the will. Instead, mom put somebody, one of the kids, maybe even the executor, on as a joint owner of that asset, a joint owner with rights of survivorship. So what happens then on the death of mom is this joint owner now is the owner of the entirety of that account. Now, the question that has to be asked is, did mom do that so that mom would disproportionately benefit that one child because that was mom's favorite child? Because that child who's the joint owner may say, that's why I am the owner of this account, because mom wanted me to receive it all myself. Or did mom put this person on unwittingly, not realizing what the consequences would be of joint ownership with right of survivorship? And in fact, would mom have preferred that, had she known that money is going to be divided 5 ways, just like the terms of the will? I don't know the answer to it. The executor might know the answer to it, but this situation I just described really gives everybody else the opportunity to claim that no, that account should pass under the will, and how you're treating it as your own asset is wrong. So again, this kind of comes back to doing the right estate planning beforehand to make sure that these sorts of situations, these sorts of problems don't ever arise. And if there is a joint ownership, we typically tell clients, if you want to put somebody on the executor on an account joint with right of survivorship, do it on a modest account. For example, a $10,000 account. So they have immediate access to funds to pay for burial, that sort of thing. Don't put somebody on as a joint owner on a larger account, because it can really lead to lots of strife and disputes and problems with your beneficiaries once you're gone.